there is a presumption that electronic media coverage by a news reporter shall be permitted in public proceedings.
All right, good afternoon, or good morning, rather. This is case number 2009-00870, Duke versus Hirschi. Counsel, could I have appearances, please?
Tyler Ayers for Mr. Hirschi, Your Honor. Or for Mr. Duke. I apologize.
And Marlon Grant and Mike Zillis here for Brian Hirschi.
All right, Mr. Grant, it's your client's motion to dismiss. Go ahead.
Your Honor, this is a transitory action. It was a tort that happened in Lava Hot Springs, Idaho. My client lives in Cache County, Idaho, in North Logan, and the plaintiff lives in Salt Lake County. And I had asked the plaintiff when they filed this to please move it to Cache County or to Idaho voluntarily, since we didn't think Salt Lake was the appropriate venue. They did not want to do that, and so we filed a motion to change venue or to dismiss the action and have them refile it in the appropriate venue. Basically, the law favors always filing a claim against a defendant in the defendant's county of residence to create due process and fairness, or where the tort actually occurred. And we just feel that it's basically forum shopping to do it in Salt Lake, since only the plaintiff lives there. The action didn't happen there, and the defendant doesn't live there. And a majority of the witnesses who saw this event and were involved in it are going to be either in Lava or Cache County. That's our main position, is that it should be here, and the statutes support that. Plaintiff has argued that, well, plaintiff does get to choose venue in some situations, but that's when the defendant is not in the same state as the plaintiff. If Mr. Hirschi was living in perhaps up in Idaho or in Wyoming or some other state, we feel that only then could the plaintiff say, well, we're going to try this action in our county. We feel that the law generally leans towards the defendant's county and his residence for a reason. He's the one being brought before the court. He needs to defend himself, and that action needs to be defended either where the tort occurred or where he lives, to create due process and fairness under the law.
Anything further?
Say that again.
Anything further?
Nothing, Your Honor.
All right, go ahead, Mr. Ayers.
Your Honor, Mr. Grant is correct. This is a tort that occurred in Idaho. It's not an alleged tort. Mr. Hirschi has already pled guilty to the alleged conduct, so therefore it's not alleged. The fact is, Mr. Hirschi attacked Mr. Duke in Lava Hot Springs. The fact is, Mr. Duke received most of his medical care in Salt Lake County, where he resides. And the last fact, and I think the most controlling fact, is that Utah Code 78B30306 is the statute that governs. And in this statute, the court has said, or the legislature has said, Salt Lake County is a proper venue. Oh, let me just read the statute, Your Honor. 78B3306 provides a venue is proper in the county where the plaintiff or principal defendant resides. In this case, Mr. Duke resides, Mr. Duke, who is the plaintiff, resides in Salt Lake County. it's appropriate if the cause of action is transitory. The defendant has already admitted that this is a transitory tort. Consequently, it is transitory. The cause of action arose outside of the state. It did arise outside of the state, and the cause of action is in favor of residents or residents of the state. The fact of the matter is, it would be obvious that we could file this in Idaho, and that would be inconvenient for everybody since nobody was up there in Idaho. So consequently, the state allows us to file it in Utah when the plaintiff and the defendant reside in Utah. If the defendant resided in Idaho, we would not be able to file it in Utah because Utah wouldn't have jurisdiction over the defendant in Idaho. But because Utah has jurisdiction over both of these people because they both reside there and the tort is transitory, then the legislature has essentially said that the plaintiff gets to pick. Now, we could have picked Cache County, and we did look at that, and we looked closely at this statute, and ultimately we decided that because the law allowed us to pick Salt Lake County, and because we are the plaintiffs, and it is more convenient for us, and because the medical providers who are going to be the ones who provide the most substantial evidence, since there's no question about whether the conduct occurred. We don't need any of those witnesses who observe this conduct because Mr. Hirschi has already pled guilty. It's really more important that we deal with the medical providers, and all of those are in Salt Lake County except for the emergency crew and the hospital up in Lava Hot Springs. Ultimately, there will be some inconvenience for anybody that's, when we've got different areas of the world that we're dealing with, except for the fact that we're doing this all on WebEx now. So it really makes the location of the individuals a whole lot less important. I presume Mr. Grant's up in Cache County right now. I'm in Salt Lake County. Your Honor, you're in Salt Lake County, and we're all doing this together. So if we had somebody that needed to testify or be deposed from Lava Hot Springs or from Cache County, there's no reason we couldn't do it in a fashion like this. Ultimately, the law, the 78B3306 is controlling. It allows the plaintiff to choose his venue. Numerous Utah state case law, have supported the idea that the plaintiff gets wide latitude in where he files that case, so long as there's jurisdiction. And in here, the state does have jurisdiction, and it's appropriate that the plaintiff pick the venue that is convenient for them since the law allows.
All right, thank you. Mr. Grant, any reply?
Yes, Your Honor. We still feel that 305 is the main statute that says all transitory actions or all transitory causes of action arising outside of this state shall, if action is brought in this state, be brought and tried in the county where defendant resides. And the question is, if it's brought in this state, well, that's what they're trying to do. They're trying to bring the action in this state, not in Idaho. It is a transitory action. Everybody admits that. It arose outside of this state, and they're bringing an action in this state. It shall be brought and tried in the county where the defendant resides. That's the notion of fairness. It would only be fair to use it in plaintiff's state if we lived in California or Florida or some other location. But that's when 306 would fit the exception. But the main rule is 305, and that should govern this action absolutely. Notions of long-arm statutes, fairness, and due process have always indicated the home state action should be brought where the defendant resides. I'm not done. The thing that backs that up, Your Honor, is that 307 says all other types of actions are also brought in the county where this defendant resides. The statute and the legislative rule leans that way. It's only in that one exception when the defendant probably does not reside in the same state as the plaintiff that the plaintiff gets to choose. But if the defendant is in the same area, the defendant is the state or the county where the action needs to be brought.
All right, anything else?
No.
Your Honor, Your Honor, if I may.
No, that's enough, Mr. Ayers.
Very good, Your Honor.
Section 306 appears to apply here. It actually contemplates a situation where both the plaintiff and the defendant reside in different areas of the state of Utah, but it gives plaintiff the choice of which county to bring it in such cases. This is a transitory action. 78B3-305 governs in general, but accepts out the situation where a cause of action arises in favor of a state resident in Utah. So Mr. Ayers is correct. In such a circumstance, it is the plaintiff's choice in terms of proper venue, either the plaintiff's county or the principal defendant's county. In terms of convenience, I don't see any strong convenience argument either way, particularly. It appears that liability may or may not be contested, but the witnesses are probably located outside the state in terms of witnesses to the actual alleged tort. The damages aspect appear to be primarily here in Salt Lake County. And really, there is no strong convenience argument when we're really dealing with just traveling from Cache to Salt Lake County in any event. So based on that, I'll deny the motion. I'll ask Mr. Ayers to prepare appropriate order.
Very good, Your Honor.
All right. Thank you, everybody.
Thank you. That's all we have.
Yep.